House Bill 255, and I ask for your favorable consideration. This is my attempt to address one of those critical issues that we've been talking about in the state, and that is of housing. I'm a young person, and so when we consider the first home that people are able to buy, it's either a mobile home or a manufactured home. And there are a lot of folks in the state of Wyoming that are wanting to make that move in life, but they encounter difficulties when interacting with their local government when it comes to getting their classification of their property changed. And so this was brought to me by a member of the community who is going through this very issue and pointed out to me that we have an instance of an overbearing local government. And so what this bill does is it goes into our statute 31-502. And you can see on page 2, it repeals the words on line 4 through 7. It repeals the words, "The county clerk may require the person surrendering the title for cancellation to disclose information necessary to determine whether cancellation is proper under law." And so right now, in order to surrender your title and get your mobile home or manufactured home classified as real property, you have to fill out a form with the state. There's a state form, but local governments are able to have their own form with the language that we have existing right now. And that's what's the word? I'm kind of superfluous, if you will. It's an additional government requirement, and it stands in the way of having that accessible housing for especially young people here. And so, again, this is my stab at trying to make the housing crisis a little bit better in the state of Wyoming, and it's a repealer. And so I do have folks that would like to testify on this bill, but if you have any questions, I'm happy to address them.
All right, thank you. Are there any questions for Representative Singh? Representative Lawley.
Mr. Chairman, thank you. Representative Singh, good to see you. Could you tell me a little bit about what the form has on it and how the local form and the state form may differ?
Representative Singh.
Thank you, Mr. Chairman. Off the top of my head, it requires that just the information associated with the title for the mobile home or the manufactured home. But in the requirements that we have in Laramie County, it requires a visit to the Department of Transportation and working with the local sheriff's department. And it involves an additional fine of $25. So all of those things are not required by the state form, but they are required in the county form.
Follow up.
Thank you, Mr. Chairman. Representative Singh, what regard is there a visit for the sheriff? I'm trying to understand just basically how the system that you're seeking to repeal actually works, what it does, what its purpose, and a little bit about that. That's why that form's kind of important in the details of what happens with the form. Anything you could kind of enlighten me to would be helpful.
Representative Singh.
Thank you, Mr. Chairman. Representative Lawley. So, and I'm not trying to indicate that somehow our county folks are belaboring a meaningless point. The purpose of visiting the sheriff would be to try to ensure that the property in question isn't stolen, that they're not fabricating any documents. But with the existing state form, a lot of this information is already covered.
Follow up.
No, thanks.
Further question? Representative Bratton.
Thank you, Mr. Chairman. So is this every county, or is this just Laramie County that you're talking about for the form with the $25 with the sheriff visit and the did you say it was a fine or is it a fee?
Representative Singh.
Thank you, Mr. Chairman and Representative Bratton. So that's part of the problem that this bill seeks to address. The forms aren't uniform throughout the state, and so the fee that I had mentioned, that is specific to Laramie County, and each county is different. And so some of them may not even use an additional form. They may simply rely on the state form, but it's not uniform throughout the state. And so this, not only would this simplify the process, it would also bring uniformity.
Further questions? Seeing none? Thank you. Let's see, are there any state agencies that would like to speak to this bill? Any other representatives? All right, we'll take public testimony. Please, if you're in opposition to the bill, please speak first. We have 10 minutes in opposition and 10 minutes in support. So would anyone like to speak in opposition to the bill? Good afternoon.
Good afternoon, Mr. Chairman, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association. We're opposed to this deletion, and the simple reason is that the information that banks receive regarding the location and making sure that the mobile home is on the right property and it's the right mobile home is critical for lending institutions and their collateral. And so this is something that would making banking just a little bit difficult. And so we oppose having that language deleted. Certainly stand for any questions.
All right, thank you. Any questions? Seeing none, thank you.
You let me off early. Thank you.
Is there any other testimony in opposition? In the room, I believe we have one online. Could we bring in the online testimony, please?
Yes, Mr. Chairman, Melissa Jones is joining the room at the moment.
Good afternoon.
Hear me all right?
We can.
Mr. Chairman, members of the Education Committee, thank you for letting me testify today. My name is Melissa Jones. I am the Crook County Clerk, but I'm here also to testify on behalf of the Clerks Association. At this time, we don't have any position on this ballot. I really just wanted to listen in and understand why this legislation was proposed. I just want to offer some information on what we use this wording for. Currently, we use the wording that is proposed to be stricken to allow the clerks to obtain all the information that we need in order to help the customer complete the form that was prescribed by the department. That's MB 303. With us being able to help them, then we can verify that they are surrendering the intended mobile home. More specifically, question 6 on the form, we think that this sentence helps us help them complete question 6 if necessary. Question 6 can be an optional thing. As to what the representative was talking about, we may need to require a picture of the mobile home. We may need to require them get a bin inspection of the mobile home so that we can verify the correct person is surrendering the correct mobile home to the correct piece of property. So that's all I have. I would stand for any questions that you have. Thank you very much.
Thank you. Are there any questions? Vice Chair Lawley.
Thank you, Mr. Chairman. Thank you for being here and for clarifying those things. What is your view concerning whether or not the state form is sufficient for you to do what the statute contemplates you doing as a clerk?
I think the state form has all the questions that we need. I hope that answers what your question is. I did poll some clerks, and it did, out of the 12 that replied, 11 of the 12 just used that state form. But again, I think that wording needs to be left in there to help us complete number 6 on that form.
Thank you. Any further questions? Seeing none, we will now take public testimony in support of the bill. Please fill the chairs.
Good afternoon, Mr. Chairman, members of the committee, Lori Urbikite. I'm with the Wyoming Realtors, and I also wear a second hat. I'm the executive director for the Wyoming Housing Alliance, which is the group that represents manufactured and modular homes in Wyoming. So I'm very familiar with this process. We are in support of this bill. It seems that it's done differently in 23 counties. Some areas, it's very simple. You fill out the state form, you sign the affidavit, and away you go. In other areas, not so much. So, but I do have experts with me today from the banking industry and from title company, and so I would turn it over to them for more detailed explanation. Thank you, Mr. Chairman.
All right, please go ahead.
Thank you, Mr. Chairman. I am Katie Kuntz, and I'm from Jonah Bank of Wyoming. I am a mortgage lender. I've been doing this for about 15 years. And the state statute form itself covers everything that's needed. The reason you have to go through this process is to get past me. If you want a loan on your home, I have to prove what that home is, where it came from, how long it's been there, that it hasn't been moved, and that both sides of the home are the same property. So with the state statute, it's a very simple process. What we have seen across the state is every county is treating it different, creating their own checklists that potential buyers have to jump through. And in doing that, they are creating a situation where houses are becoming unlendable. So you can have a $500,000 home, and if we can't go back to the original documentation, then they create a new VIN, and now it doesn't match historic documents. You can pay cash for that house, but I'm not gonna give you money for it. And that's the problem. So if it can be streamlined across, then you don't have counties deciding what they can and can't do and creating problems for homeowners. Thank you.
Thank you. Are there any questions? Vice Chair Lally.
Thank you, Mr. Chairman. Thank you for being here and clarifying that, because that was really a lot of what I was hoping to hear and the reasons. And so in your view, the state form does what it needs to do to comply with the law?
Mr. Chairman, thank you. Absolutely, absolutely.
All right, thank you. Further questions? All right, please go ahead.
Thank you. Mr. Chairman, I am Kathy Claywell, and I work at Town Square Title of Wyoming. I have been working through this manufactured home title cancellation process for over 20 years. I am for this change in this bill. I'm hoping this will simplify and make the process less cumbersome for property owners. We do have situations where the difference in counties, they do make the property in some situations unsellable, or again, as Katie mentioned, not being able to go through the financial, normal financial aspect for new buyers.
Thank you. Any questions? Seeing none. Thank you. Is there any further public testimony? Anyone else in the room? I don't believe we have any online. All right, public testimony is now closed. Sure. Mr. Meyer, would you like to come back for a question?
Just one quick question. Sorry.
Representative Bratton.
Thank you, Mr. Chairman. I just want to confirm, because you represent the Wyoming bankers, we have two kind of different opinions here about, so I wanted to ask you a little bit more about the state form and your comfort with that.
Please go
Mr.
ahead.
Chairman, Representative Bratton, I don't think that we necessarily have an issue with the state form. I think that question 6 on there is somewhat of ambiguous. Maybe there's some issues that they can deal with the county. The Wyoming Bankers Association's position is that if that helps the banks keep track of their collateral, and that's what they're concerned about, then that's where we are standing in opposition to the change. But that's only because we want to make sure we can track our collateral.
All right, thank you.
Thank you. Committee, what is your pleasure? Moved by Representative Strzok. Seconded by. I'll second the bill for discussion. Seconded by me. Is there any amendments to the bill? Any discussion? Seeing none, please call the roll.
Mr. Chairman, on House Bill 255, Mobile Home Certificate Information Disclosure Requirement, do pass. Representative Bratton?
No.
Representative Erickson? Representative Guggenmoss?
Aye.
Representative Kelly?
Aye.
Representative Lawley?
Aye.
Representative Singh?
Aye.
Representative Strzok?
Aye.
Representative Williams has left an absentee vote of aye. Chairman Andrew?
Aye.
8 aye, 1 no.
The bill passes the committee. House Bill 120 is now on the table for our consideration. Sure. Representative Strzok.
Thank you, Chairman Andrew. So what we have here, this bill is another constituent bill, and the issue it tries to fix were brought to me by some people who were treated unfairly by our state government. And their situation made me aware of some shocking facts that how people are treated by executive agencies in the administrative hearing process. So House Bill 120 would allow people to request a trial by a jury of their peers whenever an agency attempts to fine them $20 or more or take away their liberties in administrative hearings which are outside the judicial process. And across the nation and in Wyoming, executive agencies have abused the people with little oversight, and this bill seeks to remedy that by providing the people an option to have their cases heard by their peers. So if we wanted to kind of walk through it real quick. So on page 1, line 8, and it's a new section of statute is created stating that where a person is subject to a fine of 20 or more, the loss of a liberty interest, or a suspension of a license, that person can request a trial by jury instead of a traditional administrative hearing. The person can also waive this right and have their case heard as normal. And then if you want to turn to page 2, line 8, the bill states that the presiding officer of the contested case shall preside over the trial, and the remainder of this page and on page 3 states that these trials will be set up just like civil jury trials in the judicial world. And then if you want to turn to page 4, the bill makes conforming amendments to statutes relating to jury selection. And then on page 5 through 10, makes confirming amendments. And at the end of page 10, the bill states that if a person wants to appeal a jury's decision, it will do so as normal under the current statutes and the rules for appealing an administrative decision. And then on that last page 11, the bill states that the new jury rule will apply to all pending cases on and after July 1st, 2025. And I stand for any questions.
Are there any questions for the sponsor? Vice Chair Lawley.
Thank you, Mr. Chairman. Thank you, Representative Strzok. It's good to see you on that side. I usually see you from this side. Yes. So I do appreciate the intent behind this bill, but I'm trying to think through. There's really not much sidebars on it, other than if there is an administrative hearing, then there is this right, which could cost substantial money. I mean, conducting voir dire of juries, sending out, all of that takes money and resources. So I'm trying to wonder what kind of situations that might be appropriate to this and what might not, or at least to narrow it down. Maybe you don't have any thoughts about that, but that's kind of one of my concerns. And something like this could be abused. And there's no sidebar really about saying if you ask for a jury trial and lose, you might have to reimburse some of those expenses of that trial. So I don't know if we can get a balance that way and then apply it all the way across the board, but that would be some of my concerns. So you could address some of those, that might help.
Representative Strzok,
Thank you. And I would like to,
use one of your lifelines.
I would love to
friend.
use one. Thank you. Use a friend, call a friend.
Yes, phone
So
a
thank
friend.
you.
Ms.
Mr. Chairman, members of the committee, my name is Jessie Rubino, and I'm here in my personal capacity. This bill became something of interest to me after I learned about some abuses that Representative Strzok mentioned, and I think there's people in the audience that can provide a little bit more color later on in public comment as to why this bill was brought. As for the financial aspect of the bill, Representative Lawley, I think that's a really good concern. I'd like to point out that the fiscal note states that this bill as written does not modify any state agency budget or personnel authorizations. The important aspect of this bill that I think I want to point out is that this is a waivable right that someone might have. Most of the time in administrative hearings, we see things that do not rise to the level of a significant liberty interest. We don't see massive fines, aside from the situation that you might hear a little bit about later. And so I don't imagine many people would want to go through the rigmarole of a jury trial if they're facing an everyday administrative issue. However, when an issue arises that rises to the level of great public concern, I think this creates protection for the people. And these licenses were designed to protect the people. At least that's what we've been told about licensing boards. And so this would kind of allow the people to have a stake in what happens to someone's liberty interest, license, or a financial interest. And another thing that I might point out, if I may, in the administrative procedure world, a person subject to an administrative trial normally has to exhaust all of their administrative remedies before they can appeal into the judicial system. This bill does not change the exhaustion requirement that a person has to satisfy. It merely creates protections for the person within the administrative world before they get to that point. And the reason that we think this is important is because by the time someone reaches the exhaustion requirement, they've often exhausted their own financial resources to continue with their attorney, who they probably have had since the beginning, and make it into the judicial realm to appeal what's happened to them.
Thank you. Are there any Vice Chair Lawley?
Thank you, Mr. Chairman. Thank you for being here, Mrs. Rubino. It's good to see you. So I was thinking about how a citizen navigates this. So we're talking about a threshold of $20, and it sounds great that they can ask for a jury trial, but you kind of alluded to it a moment ago that for that to be effective, they might have to hire an attorney for a threshold of $20. And just walk me through that. Like, I mean, obviously they could represent themselves if they wanted and navigate that space. But could you just give me your thoughts about that?
Yeah, Mr. Chairman, Representative Lawley, I believe that if a person were to the point where they felt they needed to fight this thing all the way through, they would probably be getting counsel anyway. I don't foresee a person obtaining an attorney for every single one of these issues, but for ones where it's a very serious issue at stake, those people have attorneys most of the time anyway. And I think I'll again refer to the people who have come today. I know that they hired an attorney from the very beginning of the issue that they were presented with from a licensing board, and it's exhausted their ability to continue their business almost. So,
Please.
Thank you, Mr. Chairman. So could we speak a minute to the $20 threshold? Again, I think there's some appeal to this idea. I just see it as really, let's start at $20, jury trial. Again, we don't have any sidebars if people continue to ask for trials. It will cost the state money to do that. So the threshold might be one way to approach that. So what's your thoughts about that $20 threshold? And is it based on something specific that you chose that?
Mr. Chairman, Representative Lawley, this concept was vetted through the good staff at LSO, and that's kind of what was returned to us. And I think part of the reasoning was to kind of model it after a traditional civil jury trial, right to a jury trial. And I think it might be maybe something that Representative Strzok might be able to speak to. I personally don't believe that changing that threshold harms the intent of the bill. And I don't know how many administrative smacks on the wrist, if you will, are even $20. Some of the fines that were brought to my attention were unprecedented fines in the hundreds of thousands of dollars over licensing disputes. And so I don't think that would destroy the intent of the bill if that were bumped up.
Further questions? Seeing none, thank you.
Okay.
All right, are there any state agencies who would like to speak to this bill? Please go ahead.
And Mr. Chairman, just as a reminder, Kit Wetland from the governor's office is online and ready to go.
That's right. May we speak to the governor's office first, please? Then we'll go to the room.
Chairman Andrew, can you hear me?
We can.
Thank you, Chairman Andrew, and sorry I have to be remote. I caught the bug, and as much as I'd love to be there, I can guarantee you all you don't want me there in person right now. I'll be quick. I think from the governor's office perspective, just noting the effect this could have statewide on agencies, that's why you see me here before you today. There's a couple concerns that I think we have with the bill, and I will leave it to Mr. Demers, Director of OAH, to go through just the logistics of how his process at OAH works. But from the governor's office side, there's two main concerns, and it's not the fact that people can have a jury trial. The right to a jury trial is inviolate. It's in our Constitution. It's in the United States Constitution. It's the issue of where does that belong, in the executive branch or in the judicial branch? And I think that threshold issue is what creates structural problems too when it comes to burden and cost. So the first issue that we have is we're worried this could create substantial added costs and bureaucracy within state government. Currently, contested case proceedings are available for a broad range of activities. It's in the Wyoming Administrative Procedure Act in Title 16. And in essence, they're a proceeding where it's an intermediary step to get a more informal, quicker way from the agency to challenge an agency decision to get due process in the form of a hearing in front of them before you then exhaust that remedy and appeal it to a district court, since the district court is the only one with the ability to actually adjudicate the law as a judicial function. And the reason that step exists is so that you have people with expertise in the matter at hand that can hear the issue, and then it may be quicker and get resolved in a quicker manner than you would if you had to go through filing a petition in court, motions to dismiss, summary judgment, discovery, request for a jury trial, a process that can, especially if it involves a trial, take up to a year or more. Administrative contested case hearings, especially for licensing disputes like driver's licenses, you can get through those in a couple months sometimes. Most, if not all, contested case, actually all are subject to judicial review under Title 16. And the main reason for that is it's an executive branch agency. It's not a court doing these determinations, and people need the ability to have their full due process right heard in a court with an independent judge, not somebody from an agency as a presiding officer. As I said, there are hundreds, maybe, well, thousands of contested cases each year. And the main issue, another issue that we have is this bill is very broad in how it defines which of those are subject to potential contested case hearings. For example, on page 1, lines 14 through 15, and page 2, lines 1 through 3, that's where we get to that $20 threshold, to the significant liberty interest language and the licensing language. That $20 threshold is pretty low. And for example, workers' compensation cases, there's hundreds or thousands each year, and any of them could qualify for under that threshold. Similarly, under significant liberty interest, important language, but that will get litigated on what it actually means. There's not a set statutory definition because it's hard to define exactly what liberty interest means, which means that could be a broad category as well. And then licensing, there's so many different licenses. And one example I'd give is civil driver's license revocations. For example, if you're pulled over for a DUI, there's a criminal procedure for driving under the influence, but the actual revocation for your license, if you meet that threshold, is a civil proceeding done through contested case hearings that are then appealed to a district court. Last year alone, there were 436 requests for driver's license revocation hearings. And then in 2023, there were 527. I don't have numbers before that. Not all of those went to a hearing. Don't get me wrong. And not all those people may request a jury trial. But those are the kind of numbers we're dealing with just in the license category. And again, the issue isn't that people should get a jury trial. It's just where in the process should it fall so that it fits within our separation of powers and is actually manageable from a bureaucratic standpoint. Adding to the concern about volume is also the added work per case. Jury trials really need to be in person. During the pandemic, courts made it work where you had virtual jury trials, but it's very difficult because people can't be in the room, sensing the vibe of the room, seeing the jury, interacting. And that means that for all of these license revocation hearings, for this money threshold, you could have contested case hearings in any judicial district around the state, which would mean you'd need the physical space to conduct these hearings around the state. That comes with the meals and incidentals costs, the travel costs, the structural costs of finding those physical spaces and maintaining them. And that also means that you need to have enough people to be available to do all of those proceedings. Because right now, currently, most contested cases are done virtually. You have the presiding officer with each party, and if they have legal counsel, their legal counsel. Going back to the previous question about voir dire, that's another part of the jury process that adds burden. Voir dire is the process of jury selection, where each side has the ability to go through and ask jurors their questions to root out bias and make sure you get the most independent jury possible. That can take hours. It can take over a day for each case. And then jury instructions are another portion. It's how the jury learns what the law is when they go to deliberate on the facts. Development of jury instructions is a significant burden that the court has worked on for a long time. Applications of the rules of evidence and civil procedure. There's a question of how much more formally they need to be used as well.
Sorry, we'd appreciate if you would take the next 30 seconds to wrap up.
Yeah, Chairman Andrew, of course. My last point.
Sorry about that. I should have put that in place to begin with.
No worries, Chairman Andrew. I'll be quick. The last issue is we believe there's a potential separation of powers issue here. Only courts can conduct jury trials because it's an inherent judicial activity to conduct a jury trial and manage a jury. If an executive branch agency is doing that, we really have serious concerns that that's an overstep between the branches, especially page 3, lines 1 through 20. That's part of why all contested cases are subject to judicial review, so a court is the backstop. Juries also aren't usually determiners of legal issues. They're the determiners of facts. And then inserting a jury before a trial or a court case has happened also messes with the standard of review on appeal and knowing how much deference an executive agency decision should be given in a judicial court proceeding. With that, I'd stand for any questions.
Thank you. Are there any questions? Seeing none, thank you. Please go ahead. If you could each take about 3 minutes, I'd appreciate it.
Good afternoon, Mr. Chairman, members of the board. I'm J.C. Demers, Director of the Wyoming Office of Administrative Hearings. So the Office of Administrative Hearings is a separate operating agency within the state of Wyoming government. The Office of Administrative Hearings typically receives between 900 to 1,000 referrals for contested case proceedings per year. The more typical cases that we receive, although it can vary, some agencies use us from time to time and don't at other times, but typically it's workers' compensation cases, driver's license cases, teacher termination cases, state employee termination cases, professional license cases, abuse and neglect registry cases, unpaid wage claims, employment discrimination cases, Medicaid waiver cases, and grazing rates cases. In some of these cases, the Office of Administrative Hearings provides the final determination. In other cases, the Office of Administrative Hearings may prepare recommended findings of fact and conclusions of law And then in another class of cases, we simply provide hearing officer services for the agency. And given the time constraints that were referenced, I'm going to try to avoid repeating anything that was said by Mr. Wentland. But just structurally, our office isn't set up at this point in time where we could facilitate this. I think that we would need to potentially double our office space. We'd have to have facilities built to create a jury room and have whatever technology is necessary to adequately do a jury trial in these days. Also, if we travel, there would be an issue for hearings outside of Cheyenne of finding facilities and space to conduct jury trials. We'd definitely need to increase our personnel. We'd need additional parking spaces and all the there are all the costs associated with jury trials that Mr. Wentland referenced. And also just the time that would be involved would substantially increase in comparison to a lot of the contested cases that we do now. There's no universal time amount with contested cases. Some can go out, be done in an hour, some can be a few days. But whatever one's involved a request for a jury trial, the time involved would increase substantially, not just for our office, but also for the litigants who are involved. Thank you.
Thank you. Are there any questions? Representative Bratton.
Thank you, Mr. Chairman. Were you contacted before for the fiscal note at all? Your
I was
agency?
Representative, I'm sorry, Mr. Chairman, I was Representative Bratton.
Right, thank you.
Thank you.
I have a follow-up to that. If you were contacted about the fiscal note, this bill was numbered before session. Why isn't there any information that you're providing today in the fiscal note?
Mr. Chairman, we did provide a fiscal note. And I think that the information that I provided today wasn't at least what we submitted. Now, one of the problems with the fiscal note was that a lot of it was a wild guess on our part because there's no way for me to reasonably predict how many cases would involve a request for a jury trial. And so having done that, again, what we did submit was a guess, and very much a guess.
All right, thank you.
Thank you.
Representative Lawley.
Thank you, Mr. Chairman. Thank you for being here. I think you were here when we were generally describing some of the challenges that kind of resulted in this bill being developed. Could you give me any insight into, through the administrative process, what could be done to help or address the concern of not being heard or not having a right to get something resolved other than what already exists administratively after the process going to district court?
In general, I can only speak to my experience, but my experience is when there's a contested case before various agencies or licensing boards, and I haven't followed the case that was referenced, I suppose, but it's generally my view that those people are very conscientious and take their duties very seriously in terms of attempting to provide a fair proceeding. And certainly, when they have a hearing officer come over, we ensure that there's fairness in the proceeding. But also in terms of their deliberations, I think that the members of those boards take their duties very seriously.
Vice Chair Lawley.
Did I understand, I don't know if you said it or Mr. Wentland said it, about the right to appeal to district court. Now, could you talk just a minute about that and when that comes into play in the process?
Thank you. Sure. So under 16.3.114 of the Wyoming statutes, any administrative determination by really any agency can be appealed to district court for either exceeding their authority, failure to follow the law, making findings that aren't supported by the evidence that was presented, conduct that's arbitrary and capricious. So and when cases are referred, there's generally significant deference by the court to the findings of fact by the agency. But in terms of the conclusions of law, that's reviewed de novo by the court. And so there's, in every case where there's final agency action, that's and there's an aggrieved party, there is the opportunity to appeal to the district court and then the Supreme Court if necessary.
Representative Lawley.
Thank you, Mr. Chairman. So to try to maybe translate that out a little bit, that after the administrative process is completed, there is a right to appeal to district court. The district court would give deference to the finding of facts by the agency, but would, as you said, look at the law and application of law de novo, which means anew. They just start over and consider their own determination of that. And in that process, there's the right to have a jury.
Mr. Chairman, Representative Lawley, no, there's not the opportunity to have the right to a jury. So the district court or the Wyoming Supreme Court, when they review the case, it's based on the record submitted. There is an opportunity that you can ask, or a party can ask to have the record supplemented, generally if there's some new evidence that's discovered after the administrative proceeding, but the review is conducted on the record.
Okay, thank you.
Thank you. Further questions? And I do want to apologize. Our good secretary reminded me that we have this in our folder about the administrative impact, so sorry for that question.
Thank you, Mr. Chairman.
Thank you. Who would like to go next? Please go ahead.
Mr. Chairman, members of the committee, Kevin Bonenblust, Executive Director of the Board of Medicine. The board licenses and regulates practice by MDs, DOs, and PAs. And I have to admit, I'm unfamiliar with appearing before this committee. It's a different group, so I'm glad to be here. I'm not like in the principal's office or anything with the education. Anyway, I just want to touch to a few points if I can. First off, I want to make it clear that state agencies don't support or oppose legislation. That's not my job here. My job is to maybe give you some information on what the ramifications are of a piece of legislation, good, bad, or indifferent. And I just have a few points to make, and I don't know the facts of the case that I believe is underlying the main concern of the sponsors of this bill. But I can tell you, there's a few things to think about when you're looking at licensing bills. For one thing, the model that the Wyoming legislature has adopted is that professions sort of self-govern themselves. And so you have physicians and PAs on the Board of Medicine. You have nurses on the Board of Nursing. You have pharmacists and others on the Board of Pharmacy. It's all that way because that is the jury of your peers. And so it's easy to say, well, you're in front of an agency, but those truly are the peers of the licensee that is up, with a concern. So I think that clarification needs to be made. To the point Mr. Demers made about the findings of fact, one of the things our boards are required to do is make findings of fact and conclusions of law. That's a lot more than we expect of juries. We don't expect juries to enumerate what they found the facts to be, how they applied the law to those. That's way past what we expect juries to do, juries of lay people. I think this would be asking them to do something they're not prepared to do without support of some sort, which then leads to, do you give them an advising attorney? How do you do that? Because the court above is going to say, okay, what were your findings of fact? The Administrative Procedure Act demands it. And so those are a couple of the concerns that I do have. The other is that while this is on the one hand, understandably intended to be a block against what's perceived to be unfair prosecutions, my concern is that when we've got a doctor that's, say, running a pill mill, for lack of a better term, or is having sexual conduct with a patient, which they shouldn't do, can this be used to slow down the process? Because trying to seat a jury, trying to get it set up so we can have them there, have them coordinate with Mr. Demers' office, et cetera, that is a concern of mine. I don't know how that would work out, but I just raised that because that's something that as I sit here, I worry about. So with that, in general terms, Mr. Chairman, I'm happy to answer questions. I can't speak to the case in point, but I happily talk about the process before our licensing board.
Thank you. It was exactly 3 minutes. Any questions? All right, please go ahead.
Good afternoon, Mr. Chairman and members of the committee. My name is Rachel Philbrandt, and I'm the Executive Director for the Board of Nursing. As Mr. Bonenblust said, we regulate APRNs, RNs, LPNs, and CNAs. We also license those individuals. When I reviewed this bill, the part I wanted to bring to your attention, just for factual information, is the amount, and our numbers are small, but we do have contested case hearings. We schedule them quarterly, and on average, we have approximately 8 per year. It can go give or take. This year already, we have 7 scheduled. And I'll stand for any questions.
Thank you. Are there any questions? Seeing none, is there any other testimony from state agencies in the room? All right, we will now open public comment, starting with those in opposition to the bill. We have 10 minutes for each side. If you'd like to speak in opposition to the bill, please come forward. All right, if you'd like to speak in support of the bill, please come forward. Fill the chairs. Anyone else? One more chair. Good afternoon. Whoever'd like to go first.
Good afternoon, Mr. Chairman, members of the committee. My name is Kelsey James. I am the owner of City Drug, an independent pharmacy here in Cheyenne. I will attempt to be brief in this. I apologize, it's a fairly long story. So when we are discussing long, drawn-out proceedings and how this may take state agencies a long time, this has been a full year.
Sorry, I just want to say we have 10 total minutes.
Sure.
So please.
This has been a full year of my life. In March of last year, my pharmacy faced a licensing board issue. Up to this point, I had had no issues with the Wyoming State Board of Pharmacy. In fact, I was very close with them. We're actually 2 doors down from them. In opening my business, a lot of people asked me if that made me nervous, and I said no. I had a great relationship with them. When we became subject to an issue that we had with them, my original intent was to walk over and speak directly to them, as I knew all of them very well. I quickly realized that that was not going to be an option for us and that we did need to find a lawyer. Up to this point, our business has exhausted over $500,000 in fees, in lawyer fees, in banks taking money from us because of the legal proceedings, in fees to the State Board of Pharmacy. And so some of the points that I would like to make to this is just how unfairly we have been treated. 6 months ago, I sat in this exact chair and was given no opportunity to speak. And there was over 100 people behind me in this room that were also not given an opportunity to speak. There was 150 people on Zoom that day that were not given an opportunity to speak. The Wyoming State Board of Pharmacy informed every single one of our patients to come to a meeting about my pharmacy, and that if they had anything that they would like to say, that would be the place to do it, that they would be able to speak at that meeting and talk about us and say what they thought was right. And when they came to that meeting, it was completely shut down. No public comment was given. It was an absolute outrage. From the beginning, we have been given no due process in anything that we have gone through in this. We have been railroaded, quite frankly, from a licensing board. We have reached out to every government official that we could think of, every single person that could offer us any help. Half of the members of that board that sat here that day to provide us discipline are my competitors. And so when we are talking about things like burdening costs and how many hours, we just heard a gentleman say it might take hours, it might take a day. It's been a year of my life fighting for my patients. In the end of this, we ended up signing a settlement with the Wyoming State Board of Pharmacy. A settlement that we presented in an attempt to keep our doors open. We were 15 minutes from closing our pharmacy completely. And we came to them with a settlement in an attempt to keep my business. And we offered them a suspension of my license specifically, although the things that were being accused of were not done by me, had no fault of mine, but did happen inside my business, and I do take accountability for that. The Wyoming State Board of Pharmacy rejected the suspension of my license and decided that it needed to be revoked completely. after agreeing to revoke my license. The Wyoming State Board of Pharmacy then decided that was not enough. They indicated through email communication that they would not be following any procedure with us as long as I, specifically Kelsey James, was involved in this business. They are demanding that I sell the business that I have built, that I have spent my entire life working for, that I came back to this community to build. The outreach, the community has given us has been incredible. We've donated over $60,000 to this community in 2 years of business because that's how much we care. The lawyer fees were over $80,000. We paid $60,000 to the State Board of Pharmacy after they originally demanded $400,000 from my small business. We have had banks take money from us and call our notes because of how long the proceedings took from the Wyoming State Board of Pharmacy. This has gone on for a full year. In 15 minutes from closing my facility, we didn't lose a single one of our 23 staff members, and our patient base is still huge. We have done everything we can to help this community, and in doing that, the overreach that the government and the Wyoming State Board of Pharmacy has imposed on us is one of the most difficult things I've ever witnessed in my time of living here. The government's office, or the governor's office specifically, on the day that we had signed the settlement and were agreed to stay open, the next day, after I had talked with countless doctors and patients and facilities in this community, informing them that we would be able to stay open and continue to serve them, the governor's office sent email communication stating that we'd be closing. And when I inquired about that and asked why that happened, they said it was just a mistake. It was just a mistake that came from them. So I am asking for this bill today to be taken very seriously because I have not been given due process in this. I have not been given an opportunity to speak until today. Thank you very much, Mr. Chairman and members of the committee.
Thank you. Maybe committee, we can hold our questions for everyone till the end so they can all get their full time to speak. Please go ahead.
Members of the committee. The woman sitting next to me is the best pharmacist in the state of Wyoming. Her business is about to go bankrupt based on the actions of the Wyoming State Board of Pharmacy. She is forced to sell. I do not understand how that is constitutional. She is forced to sell her business by March. We asked for an extension of the $58,000 fine. They said no. I urge you all to look at every single one of the minutes and the recordings and see the unprofessionalism of the Wyoming State Board of Pharmacy. I urge you all to look at the legalities between our competition, and quite frankly, his name is Jim Massengill. He was on the Wyoming State Board of Pharmacy. And talking about the case, outside of the case, with the executive director. And their proceedings after the fact, and going through each one of the emergency meetings and special meetings and annual meetings, to where they don't understand what they're supposed to do and the legalities and how they're supposed to run the meeting. He voted. We have a 2,000-page document of email communication between governor's office and internal members of the board. They were trying to take it from the second they entered our door. They were trying to take it from the second they entered the door. My kids are not going to be able to eat because of this. Her family is going to lose everything. She's on the verge of going bankrupt. Thank you.
Thank you. Please go ahead.
I'm Chuck James. I'm the father. The question that I have and that I've seen, and I've read this bill repeatedly, I've also read some of the guidelines, not only from the Board of Pharmacy, but from other boards in the state of Wyoming. And if, frankly, I'll be honest, almost every board in the state of Wyoming, if they don't like the color of your eyes, they can pull your license. It's that damn simple. That being said, in this bill, I was appalled when I saw the $20 minimum there, or whatever that's called. That should be about $20,000. That would make it a little bit, I mean, you wouldn't have somebody wanting a jury trial for a driver's license revocation. This is serious. I mean, we're talking about people's lifestyles here and their businesses that can be taken just because on a whim. I would ask each and every one of you to read the guidelines for some of these boards in this state, because they have free rein over just about anything they want to do. And that's why this bill, and I had talked to my daughter initially when this whole thing blew up. I had talked to her, I said, we need to go to the legislatures. They're the ones that can do something. This board and any of these boards, they can do whatever they want to do. So we need to get the law changed so that they don't have free rein like this to just eliminate somebody's livelihood and their business because they're a competitor or because they don't like you.
Thank you.
Thank you.
Are there any questions for anyone up here? Representative Kelly.
Thank you, Mr. Chairman. The only question I have at this point is, so far, all the proceedings and all the issues, they have all occurred when dealing with the Office of Administrative Hearings?
Please go ahead.
No, they were not. We were going through the process, and we, even in a special meeting, I don't know exactly what the date was, we notified the State Board of Pharmacy that this was going to be a contested case hearing, and the president of the board, Brenda Upton, had absolutely no idea how to handle that administrative proceeding. They did not have a hearing officer. They did not proceed forward with it after the fact. She was forced into the settlement under duress. And furthermore, people, members of the board and the member of the public appointed by the governor in the name of Patrick Fitzgerald worked for HealthWorks, which was a government facility that was funded in $6.5 million in ARPA funds. So eliminating the competition and having a member of the board with the ability to vote and without recusing himself is absolutely so unprofessional.
Representative Kelly.
I'm sorry if I'm not understanding this correctly, but you were never even given the opportunity for a hearing with or without a jury. Not even a hearing was allowed.
Please go ahead.
We went through, I don't know the exact terminology, but I would say it was probably a hearing. However, we identified that it was a contested case hearing, which has different legal proceedings based on Title 33 and Title 16. And we were not given the opportunity to have a hearing officer, as the Board of Administrative Review stated. We did not have a hearing officer. The hearing officer was President Brenda Upton.
Follow up? Further questions? Vice Chair Lawley.
So as a result of what happened and where you are in the process, you did not reach a point of having a right to appeal to the district court. Is that correct?
Please go ahead.
We did appeal to the district court.
Okay.
However, the determination of that took too long. It took 3 days. And within that 3 days, we did not have an opportunity. At that point in time, we were forced into the settlement. And within the settlement, we had to waive our right to appeal, otherwise our doors were closing. I contacted multiple legislative members, and the response that I got was, it sounds like a personal matter. Sounds like a personal dispute. Personal disputes take time and money. Both of those would have shut down our doors. And so no, the answer to your question is no.
Thank you. Yes.
Yes, Mr. Chairman. Representative Lawley, when we appealed to the district court, we attempted to file a temporary restraining order to make sure that our doors would not close, that we were still able to help patients. We serve the majority of the homeless population in Cheyenne and low-income families. So when we did that, we were attempting to stop the suspension of the license. And in doing that, in those 3 days was when we went into the quote-unquote contested case hearing without a hearing officer. In the settlement, they put in there that we are not allowed to appeal. We are not allowed to do anything after signing the settlement. In an attempt to keep our doors open, to serve our patients, and to keep 23 people employed, we had to agree to the settlement or close immediately.
Thank you. Thank you very much for coming.
Further questions? There's something you'd like to add?
Yes, I'd
please.
like to add.
A minute, please.
I met with the governor and presented him, was probably about a week or two after this happened, the original meeting, and I presented him 500 petitions signed by patients of my daughter and people in the community. He said because it was a licensing board and they basically controlled themselves, there was nobody that controlled them, that he would not be able to help in that aspect.
Thank you. Committee, I think we need to close public testimony at this time. So this bill, I think, was a heavier bill than I had realized, and these were all the bills we were going to get to that we have in our file, and we were not going to have a Friday meeting, but the good vice chair has a few ideas she'd like to work on to solve some of the issues that the agency brought up, but also keep the bill beholden to its original purpose. So I think we will have that Friday meeting, and Vice Chair Lawley will chair. Unfortunately, I'll be gone for a funeral that day, but I think we will continue this on Friday. Would you like to add anything, Vice Chair Lawley?
Thank you, Mr. Chairman. Yes, I think we should hold this bill over till Friday, but we have closed public testimony. Anyone's welcome to come on Friday, but we won't be receiving any public testimony. We'll work the bill together and have a little time to digest some of this. It's easy for me to say it's a lot, but we have been through a lot, and I don't fully understand exactly where all the breakdown was, but I will say it's clear there was a breakdown. This did not work the way that we would have liked it to, that we presume it will. And again, I'm sorry for that.
Just a quick question.
Thank you
may
for
I
your
ask?
testimony. Sorry, we're out of time. You can ask us after the meeting
Sounds
is
good.
finished.
Thank
Thank you. All right, House Bill 257 is now on the table for our consideration. Representative Singh.
Thank you, Mr. Chairman, members of the committee. I bring to you House Bill 257, barber apprenticeships, and I ask for your favorable consideration. I realize we're on a time crunch, so I will cut to the chase. So this is a bill about creating opportunities, folks. I really appreciate the work that our local barbers do. It's one of the few trades that I see people getting really excited about. It's a creative outlet, and not only that, but just the atmosphere of a barber shop is one where people are able to go and socialize and also get good work done, and they leave the shop looking better than how they walked in. And so I appreciate that a lot. And so this bill, what it does is it creates an additional opportunity for people, young people, to hone their skills and to develop professionally. And so just walking through the bill, on the first page, it establishes that a registered barber can have up to 2 apprentices. at a time, that the apprentices, they'll need to have at least 36 hours of training in safety, that an apprenticeship would take not less than a year and not more than 2 years in order to complete their apprenticeship, and there may be some amendments that come up, but an apprentice shall have at least a high school diploma or the equivalent to be authorized to work in the United States, that they'll pay a registration fee to be collected and established by the board, that the apprentice will have to pass an examination by the requirements set by the board, and that there has to be a certain set number of hours as established by the board. So this bill gives a lot of that authority to create the guidelines to the Board of Barbers, which is our Agency 16, which exists. And so this is, I'm really trying to work with the agency to make sure that we do this the right way and that we create these opportunities for folks that want to get involved in this line of work. So on page 4, it just creates the definition of what an apprentice is, someone who has been selected by a barber. So it's they have to be chosen by a barber in order to participate in this, and on-site training to acquire a certificate to practice as a registered barber. For the fees in the next section, it just adds that the board will establish and collect fees for apprenticeship registration. And then in the next section, from page 5 going on to page 6, it establishes that someone who completes an apprenticeship and is not less than the age of 17 years old is able to be a barber. And then it kicks into effect on July 1st of this year. And I believe there are some folks that would like to testify on this bill, but if you have any questions, I am ready to stand for that.
Representative Kelly.
Thank you, Mr. Chairman. Just a curiosity, why is this necessary? What's the impetus of this bill?
Representative Singh.
Thank you, Mr. Chairman. So right now, the way that people would be able to become a barber is they would need to go to school in order to do that. And they would need to fork over a significant amount of capital in order to pursue what they want to do with their lives. But I don't necessarily believe that the only way to receive an adequate training is through academia per se, but rather this is one of those situations where on-the-ground training can be just as effective. And in fact, by working in a barber shop and being trained on the floor of a barber shop, you're actually able to build those relationships with your clientele in person, and you'll have an understanding of who you're working with, the members of the community. It has the potential to be a really wholesome experience, and so I'm excited to bring this bill.
Thank you. Further questions for the sponsor? Seeing none, we will open public testimony. Who's here to testify on this bill? I don't think there's a need to put time limits on it, but.
Cut to the chase.
Right. Good afternoon.
Good afternoon, Chairman. I'm Angel Maldonado, representative of the Barber Board, Vice President. And pretty much, we just have a few questions on the bill and would like to just work with you guys as far as establishing more of the rule, just to have a better idea of how this can go forward. So first question would be the required number of years practicing as a barber participating in the apprenticeship program. Would the board be able to set the rule?
So generally, we're the ones here to ask questions, but since we have 30 minutes, I'll allow.
No, I don't want to make this too
If anyone
difficult. It's just,
has the answer, we could try to provide it. Vice Chair Lawley.
Thank you, Mr. Chairman. I was just going to turn it over to Representative Singh to ask if he has rulemaking rather than me search in here. Is there some specific rulemaking authority for the?
Representative Singh.
Thank you, Mr. Chairman. Let me look at this question.
Yep.
Yep, Mr. Chairman, on page 6, it does say that in section 3 that the Board of Barber Examiners shall promulgate all rules necessary to implement the provisions of this act.
Okay. Also,
Please go ahead.
oh, sorry, Chair. Mr. Chair, could I ask?
Yes, please go ahead.
A registered barber may select persons to participate in the barber shop. As a registered barber may select persons to participate in the barber shop, does that mean the barber has to be the owner?
Representative Singh.
Thank you, Mr. Chairman. To the question, as it's written right now, they wouldn't necessarily need to be the owner. It would be anyone who is a registered barber. But if the board would feel as if that should be tightened up, that could be amenable language, but the purpose of the bill is to create as many opportunities as possible.
All right, thank you.
Thank you, Mr. Representative Sung and Mr. Chairman.
Please go ahead.
Also, Mr. Chairman, Representative Singh, so it says not less than 1 year, but not more than 2 years. Is that, can we word that to where if it needed to be over 2 years because of a situation where a candidate is sick or they have a situation in their life and they didn't complete in 2 years, can we have it to where it can probably be over 2 years if there was a significant situation in a candidate's life that was going for this apprenticeship program?
I believe we can consider that amendment if maybe Representative Singh would like to come back and bring that amendment when we work the bill. All right.
Thank you, Mr. Chair and Representative Singh. And then just one last thing, as our statute is written as of right now, 2 years of high school, and it's not required to have a high school education to become a barber and at least be 17 years old. As you, in the writing, it says you need to have a high school diploma. Or can we keep it as we have it in our statute?
Where do you see, can you suggest
Is
we
it
see that in the bill?
33-7209?
Mr. Chairman.
Representative Singh.
So, thank you, Mr. Chairman. So this would be a suggested amendment, and I'm definitely, I would consider this friendly. So right now in statute 33-7-209, Romanet 1, it specifies that someone who has graduated from an approved barber school or college and has an education equivalent to the completion of second year of high school and is at least 17 years of age. That's the current standard for being able to get a license in this way. And so we could definitely change that language to align with the existing statute.
All right. Sounds good. Thank you. Any further suggestions?
That's pretty much just from the board. So outside of that, I want to speak as Angel Maldonado from the owner of the Presidential Barbershop. And why I see this would be a good fit for the community. One, I like to take a lot of responsibility for why this community has enhanced to participate when more people wanted to be barbers. When I first got here, I had 4 options. Not saying they were bad options, it was just options of the state was just more old school. They had old school shops. So when I had the chance to provide an experience to where I brought like my Brooklyn, New York swagger to Wyoming, we kind of opened it up to where it kind of got a little more modernized to where, you know, the haircuts of quality were more significant. You didn't just have to go to Denver to the big city to get a big cut. We brought a big city vibe to Cheyenne, which provided Cheeks to adopt having a barber program. So which was great because now more people didn't have to just go to school to be hairstylists just to try to be a barber in shops, which was pretty much almost going to be illegal anyway because you still couldn't practice with a razor. So it was nice that Cheeks actually did do a barber program. But the only unsuccessful part of that is people just can't go to school full time. You know, the day-to-day living with some people's experiences on what they have to deal with is pretty tough. So having an apprenticeship program, I'm also an apprentice. We had schools that would give us evening classes. And this is something we could work with our local schools to see if this is something they could provide. And now we can have people in shops getting a better experience, learning how to be better barbers, learning how to deal with customers, and also getting the knowledge they need to pass the test to be better in this industry. So I think this is a great idea, great program that can help the whole state of Wyoming produce better barbers and get the barber numbers up to be a better competitive board. So, thank you, Chairman.
Thank you. Are there any questions? Seeing none, thank you. Any further public testimony? All right, public testimony is now closed. Committee, what is your pleasure? Moved by Representative Strzok, seconded by Representative Guggenmoss. Kelly, Representative Kelly. Either one, works just the same. Representative Singh, you can come join us. If you... All right, are there any amendments to the bill?
I understand. Representative Singh should have some.
Yes.
I do have one on page 1 if he doesn't suggest, if he doesn't have one.
Okay, let's just go through page by page, and we'll do it that way. So on page 1, are there any amendments?
Yes, Mr. Chairman.
Vice Chair Lally.
Thank you, Mr. Chairman. I'm wondering, to the point about the ownership issue, is if we just put something after a registered barber may, and then with permission of owner if needed or if necessary. But I think there's a point there about some kind of a permission if they don't own the shop. And that might be a good way to do it, or it might be a better way, but I do think that that's a point that ought to be addressed in the bill. That, so we don't put a conflict in there that.
Representative Singh.
Thank you, Mr. Chairman. Representative Lawley, yeah, I believe that would be an appropriate change. What's the language that you just put in there?
Vice Chair Lally.
Thank you, Mr. Chairman. What I was thinking of, again, on line 12, where it says a registered barber may, with permission of the owner, and if he is the owner, he's talking to himself there, and select persons, or something like that. That may be conceptual a little bit, but I think that would be maybe the place to put that and address that issue a little bit.
Representative Singh.
Thank you, Mr. Chairman. Representative Lawley, yes, I would consider that a friendly amendment.
Further discussion? Seeing none, we are voting on the amendment. All those in favor say aye.
Aye.
All those opposed say no. Amendment passes. Any further amendments on page 1? Page 2?
Mr. Chairman.
Representative Singh.
Thank you, Mr. Chairman. I would like to amend the language on page 2, line 21, to conform with existing statute 33-7-209 Romanet 1. And it would read, shall have, or, sorry, I'm working on the fly here. Shall have the education equivalent to the completion of second year of high school and is at least the age of 17.
Discussion, or is there a second on this amendment? Seconded by Representative Strzok. Discussion. Question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. Amendment is adopted. Further amendments on page 2. Page 3. Representative Guggenmoss.
Thank you, Mr. Chair. Did we need to do anything with the 1 year and not more than 2 years?
You're welcome to.
Okay. So I'd like to amend that to where
Maybe ask them again for sure, so we can. Maybe ask them again for sure, so we can.
Would you like to provide us input on that? Please come to the mic if so. Good. Mr. Mandela.
Thank you, Mr. Chair. Representative
Guggenmoss.
Guggenmoss. Yeah, just if a candidate had a situation where if they needed over the 2 years, I mean, somebody had a child, somebody was very sick or something, or any kind of situation that would have happened, it would still allow them to finish over the 2 years. But still nothing less than 1 year.
Thank you. Representative Guggenmoss.
Mr. Chair, thank you. Would it be appropriate to be like the equivalent of 2 years?
Can you tell me page and line number?
Representative Guggenmoss, where are you? In the right
Page 2, line 16.
Thank you.
We could just,
You wanted to add a couple years to that year, it's just 4.
Well, yeah,
Not more than 4 years.
Please go ahead.
I wouldn't be opposed to that. I think that would be good. Just an allowable time, just in case somebody had a significant, I mean, anything can happen, an accident, surgeries, or just anything that's significant can happen to someone's life. It wouldn't stop them or your program. You got to start all over again and lose your time. So just something we could write that if something were to happen significantly, you still have the time to get it done.
Thank you, Representative Guggenmoss. Do you?
Thank you, Mr. Chair.
Thank you,
So if we
Chair.
could just do a 4-year, not more than 4-year.
Is there a
amendment?
second to this amendment? The representative saying, discussion, I think adding the 2 years makes sense. I think just having a longer amount of time than specifying what may or may not happen to a person would just be cleaner. Further discussion? Seeing none, we are voting on the amendment. All those in favor say aye.
Aye.
All those opposed, no. Amendment is adopted. Page 3.
Thank you for that. I've moved at that. This is the funnest bill we've ever had.
I know, it is the funnest bill we've
So far, this one, yeah. We're not done with the Senate bills, guys. It could be really fun.
Oh, I'm sure, from the Senate. Page 4. Nothing. Page 5. Am I going too fast?
Nope.
Page 6. Page 7. Any discussion on the bill?
Mr. Chairman.
Representative Singh.
Thank you, Mr. Chairman, and everyone on the committee. I'm really glad we were able to line this thing up.
Question.
Question being called. Oh, well, please call the roll.
Mr. Chairman, on House Bill 257, Barber apprenticeships do pass as amended. Representative Bratton?
Aye.
Representative Erickson?
Aye.
Representative Guggenmoss?
Aye.
Representative Kelly?
Aye.
Representative Lawley?
Aye.
Representative Singh?
Aye.
Representative Strzok?
Aye.
Representative Williams has left an absentee vote of aye. Chairman Andrew?
Aye.
9 ayes.
All right, thank you. We are adjourned.